Good morning over here in LA. Still good morning, good afternoon perhaps where you are. And a good Erev Shabbos and a Freilich and Hanukkah. Happy Hanukkah. Let's light up the darkness. Who's in the house on a Friday morning or afternoon? Bill in Poplar Bluff, Missouri. Joe in the Inland Empire. Sharon in New Jersey. Gordo, hello from Scotland. Always good to see you on Fridays live. Shandora in the Bronx. Karen in Northern California. Ella in Southern California. James, always good to see your name. Checking in from Indianapolis. Alan in New York City. Marjorie in Georgia. Welcome everybody. Our class today is sponsored by Mary DeSaro for the healing of our aging frailty. Mary, may you be strong and uplifted. You and all your loved ones, thank you so much for enabling us to share more Torah with more people around the world. May you and all your loved ones be showered in blessings and good health. And we say Amen. All right, we start early and we try to keep it moving on Fridays. Since people on the East Coast, Shabbos is looming. But we do have an opportunity, which is rare in Sanhedrin, to do a double daf. So we're getting a jump on that. Our pages are 9 and 10 here in Tractate Sanhedrin, the 24th volume of the Talmud. Continuing our discussion of Mishna number 1 here in chapter 1. Pick this up about halfway down the very short page 9a, and we should get through a good part of 10 today. Ravina says an explanation that the case in the Mishnah we were discussing yesterday is one where where we were talking about a woman who was accused of adultery, but there's not witnesses there for whatever reason. Either they didn't see her commit the adultery or they didn't warn her that if she committed adultery, it would be a death penalty offense. So the capital punishment aspect of the crime is off the table. She's not liable to the death penalty the way she would be for adultery. If witnesses saw it and warned her that if she commits the adultery, she would be subject to the death penalty, and then she did it anyway and in front of the witnesses. But if all those elements aren't there, it's not a death penalty case. So does it need 23 judges just for the monetary law aspect of it, that if indeed her husband is saying, okay, well, I thought I was marrying a virgin bride and she's not, therefore, at least the ketubah, the marriage contract has to be reduced in value from if he was marrying a virgin versus where he's not marrying a virgin. So for the monetary component of it, could that be judged by 3 judges rather than the 23? And one view yesterday was, well, publicity might get out that she's accused of adultery, and then witnesses who actually saw her do it will show up, and then it could become a capital case. Or if there are witnesses who say that they saw her do it, even though they didn't warn her, are found to be conspiring witnesses, then perhaps they would be subject to the death penalty for bringing this malicious slander. and it could turn into a death penalty case. And that's why one view was we need 23 judges for this kind of matter. So continuing that discussion, Ravina says a different explanation. He says the case that we were discussing in the Mishna is one where one of the witnesses is found to be a close relative or a disqualified witness, but two valid witnesses still remain, right? So now you can establish a matter in a Beis Din, in a rabbinic court, only by the testimony of two witnesses. What if there were three witnesses? And then, okay, it seems like, okay, well, you have an extra witness. Very nice. You didn't need it, but you have three witnesses. Okay, but then it turns out that one of the witnesses is disqualified, perhaps because the third witness is a close relative of the accused. Well, sounds like, so what? So you disqualified one of the witnesses. Now we have two witnesses. You can establish a matter by the testimony of two witnesses. So does it matter that the third witness is disqualified? Answer, yes, it does matter, as we shall see. So Ravina is saying where one of the witnesses is found to be a close relative or disqualified witness, but two valid witnesses still remain. And Rabbi Meir and the rabbis disagree with regard to the issue that is the subject of a dispute between Rabbi Yosei and Rebbe, i.e. Rabbi Yehuda Hanassi, with regard to the opinion of Rabbi Akiva. So here's something that all the sages were familiar with, and now we're going to learn about. As we learned in a Mishnah, Tractate Makos, page 5b, that Rabbi Akiva says, when the verse states in Deuteronomy 17:6, at the mouth of two witnesses or at the mouth of three witnesses shall a matter be established. It's an odd thing for the Torah to say. Once you know that you can establish a matter by the testimony of two witnesses, why does the Torah have to mention three witnesses? Right? If you just need two, okay, well, three includes two. So why does the Torah add this extra phrase, by the mouth of two witnesses or three witnesses? So what does Rabbi Akiva do with this seemingly superfluous language? He says that the third witness is mentioned only to be stringent with him and to make his status like these other two witnesses. Meaning that if a group of three witnesses is found to be conspiring witnesses, right, people who are conspiring to give false testimony, well, the third one might claim that his testimony was unnecessary and therefore it did no harm, since it could have been done with two witnesses. The Torah nevertheless imposes upon him the same strict punishment as his peers. So if this false testimony from a group of three was given in a death penalty case, where if their testimony was accepted by the court, the defendant might be sentenced to the death penalty, and then it turned out that these three conspiring witnesses were liars, then they would receive the punishment that the defendant would have received had their testimony been accepted. And if it's a death penalty case, then the conspiring witnesses are going to be executed, and not just two of them, but all three. Even though the matter could have been established by the mouth of two, so you might have thought that at least one of the three could be excused. No, they all committed the same crime, but bringing this false testimony in a death penalty case, and so they would all be liable to the death penalty. That's what Rabbi Akiva is teaching us. Now, Rabbi Akiva elaborates upon the implications of this law. So once you say that, okay, so the Torah included the third mention of the third witness to teach you that if all of them are rendered conspiring witnesses, all of them are subject to the same punishment. What else do we learn from that? If so, the Torah punishes the one who acts as an accessory to transgressors with the same punishment as the primary transgressor. Right? This is like the felony murder rule or the conspiracy law. You know, that if you're part of a conspiracy to commit murder, okay, so even though, let's say there were three people in a conspiracy to commit murder, and two of them actually plunged the knives into the murder victim, but the third, who was part of the conspiracy, you know, is going to get the same penalty as the other two. And what else are we going to learn about this? All the more so, now Kal v'chomer, right, if the Torah punishes one who acts as an accessory to a transgression with the same punishment as the transgressors, Kal v'chomer, all the more so, God will grant the reward to an individual who acts as an accessory to one who performs a mitzvah, like the primary one who performs a mitzvah. For the measure of good is always greater than the measure of suffering, which we learned in Tractate Sota. So this is a beautiful teaching. And for example, one of the reasons why perhaps somebody who doesn't have the time or the capacity or the inclination to learn a lot of Torah will, donate money to yeshivas where Torah is studied, because when you enable Torah study, you're participating in the merit of that Torah study. Whenever you're assisting someone to do a mitzvah, you are joining in the merit of that mitzvah. Additionally, this also teaches us that just as in the case of two witnesses, if one of them is found to be a close relative or a disqualified witness, then their testimony is nullified. As the single remaining witness is not able to testify alone, right? So if there were two witnesses to establish something, we saw this guy rob a store, and then one of them turns out to be the brother or other kind of close relative of the defendant. So as a close relative, he's disqualified from giving testimony, let's say, against his brother. That would only leave one witness. And by the testimony of a single witness, we can't establish a matter in court. So the defendant's going to escape. Now, what if there's three witnesses? And one of them is the brother of the defendant. So you would think, well, okay, so he's disqualified, but we still have two valid witnesses who are not related to the defendant. So we should be able to convict him. And here we're learning, no. Because it was a group of three witnesses and one of them is disqualified, the other two, their testimony is also disqualified. This is counterintuitive. We would not have expected this. So again, let me just read that again. Just as in the case of two witnesses, if one of them is found to be a close relative or disqualified witness, so their testimony is nullified because the single remaining witness is not able to testify alone, so too, in the case of three witnesses, if one of them is found to be a close relative or a disqualified witness, the testimony of the three is nullified. And from where is it derived that this applies even to a group of 100 witnesses? And the verse states, witnesses, plural. This principle applies to any group of witnesses. Now, this is really strange. Are you saying that if there's like a crowd, and in the crowd, one of the members of the crowd was a relative of the defendant, that, that therefore the whole crowd is disqualified for acting as a witness to a crime that this guy committed? Well, not exactly. So let me just read the halacha, the law, as it is, sort of set down. Presumably Rav Steinsaltz wrote this, or the committee that put together the Koran Talmud. But this is a law as it's written in Shulchan Aruch, right? So here we go. If one of them is found to be a relative or a disqualified witness, if one among a large group of witnesses is found to be a close relative or a disqualified witness, the entire testimony is not valid. This is the law, is the halacha, only if all the witnesses intended to testify. If not, the testimony may be upheld on the strength of the valid witnesses. So it's like all of them witnessed it and at that moment had the intent to later testify, seemingly as a group. Then if any one of them is disqualified, the rest, all of them are disqualified. But if they didn't have that intent at the time, then we can just dismiss the disqualified witnesses and keep the rest. So how is this determined? The court must ask the witnesses if they witnessed the event with the intention to testify about it thereafter. And if so, the testimony is not valid. Very interesting. It's almost like, did they go to the event expecting to see a crime so that they could act as witnesses later? That's not usually how witnesses end up being witnesses, right? You just happen to be there when a crime happens. But, somebody says, hey, I think that this woman is cheating on her husband with so-and-so. Let's go see, and if we catch them, then we can testify. That's where they're actually going on purpose to be witnesses. And if they went as a group and one of them was a disqualified witness, all of them would be disqualified. Nevertheless, some say that the testimony is not valid only if the disqualified witnesses in question actually come to the court in order to testify, and their having seen the events with the intent to testify is not enough to include them in the party of witnesses. So it's interesting. So if they come to court for the purpose of testifying, then if one of them is disqualified, they're all disqualified. But if somebody didn't come to court, so when that first group is disqualified, we could say, well, hold on a second. There are other witnesses. Let's bring them here. Then we could accept that testimony. It's a very interesting, sort of exploration of this law of what is a group of witnesses and what isn't. And while it may be counterintuitive, I think there's a lot of wisdom here. Because people who start talking about a matter among themselves as a group, that will certainly affect their testimony later, right? Because they'll sort of come to some kind of an agreement about what happened. I saw this, I saw that. And it might definitely impact their thinking and their memory about what they saw. These principles apply whether it is a case of capital law or of monetary law, as the law is in accordance with the ruling of Rebbe. Others say that in capital cases are treated different than monetary law, but that's not where the halacha ended up. And similarly, if one of many signatories to a contract is a close relative or a disqualified witness, it is clear that they all sign with the intent, and so there's a bunch of people who signed, and one of them is disqualified. So, if all of the people signed with the intent to function as witnesses, then the contract is nullified. If not, which is interesting, well, what do you mean? If they signed as witnesses, didn't they have the intent to be witnesses? How else could they have signed the document? I'm not sure, but if they were intending to be a group of witnesses and one of them is disqualified, they're all disqualified. But if they weren't functioning as a group, then if we have sufficient witnesses that are not disqualified, we can use that to uphold a contract. So that's how that law ended up. Now let's keep reading the discussion. So the Tanaim, the sages of the Mishnaic period, discussed how Rabbi Akiva's opinion is to be understood. Rabbi Yosei says, in what situation is this statement that if one of them is found to be a close relative or a disqualified witness, their testimony is nullified? In what case is this said? In cases of capital law. But in cases of monetary law, the testimony may be upheld with the other witnesses. But Rebbe says that Rabbi Akiva's opinion applies to both cases of monetary law and cases of capital law. And when is this so? When the relatives or the disqualified witnesses also warned the transgressors and therefore actively included themselves in the group of witnesses. But when they did not warn the transgressors, then they are not counted as witnesses at all. So in other words, if it's a capital case where warning is part of it, right? In monetary law cases, warning is not part of it. You say, hey, if you steal that money, you're going to be subject to the penalties for stealing money. We don't require that kind of a warning in order to find somebody guilty of theft. That's only for crimes that include the death penalty or lashes, that the warning is necessary. So then who does the warning? Is it the people who are going to ultimately be the witnesses in court? They themselves have to warn the defendant that if you do this, you're going to be liable to the death penalty? Or can somebody else issue the warning and these people act as witnesses? We're going to examine that question momentarily. But right now, what Rebbe is saying is that that's how we define a group of witnesses. The ones who, in a capital case, issued the warning together. So if somebody didn't issue the warning, then they're not part of the group. And they could act as witnesses separately if people in the group of witnesses, if one of them is disqualified, they're all disqualified. But these other people who saw what happened, didn't give a warning, they can act as witnesses. They're not disqualified from acting as witnesses. Now, the group that issued the warning, if it's disqualified, then there's no warning, but perhaps the witness testimony can establish some other matter than whether the death penalty is applicable or not. Now we're on page 9b. So, if this were not to be so, Rebbe's view, if this were not to be so, what should two brothers and one other person do if they saw someone kill another person? Now, this is also interesting. Two brothers. Now, we've been talking about the relationship between a witness and the defendant, right? That you can't be a close relative of the defendant and give testimony about him. Now we're also hearing that the two witnesses cannot be close relatives of each other, right? So if this were not to be so, what should two brothers and one other person do if they saw someone kill another person? If the mere fact that they saw the event invalidates the testimony because they're brothers, the two witnesses of each other, then no one can ever be tried for a transgression that is committed in the presence of witnesses who are close relatives of each other. If one may decide whether or not he will be a witness, one of the brothers may join with the third person in warning the potential transgressor, and thereafter constitute a pair of valid witnesses, and the other brother could just stay out of it. That's if they have the choice. And similarly, the Mishna is understood as discussing a case in which a betrothed woman committed adultery, right? She's not married to her husband yet, but she's betrothed. And we know that to break off a betrothal requires a get, right? A bill of divorce. And that's why if a woman, cheats while she's betrothed, that is considered adultery and it is a death penalty offense. So similarly, the Mishnah is understood as discussing a case in which a betrothed woman committed adultery, and of the three witnesses, two of them were brothers. So if one of the brothers refrained from warning her, then the remaining two witnesses may still testify against her according to Rebbe. In this situation, the case must be tried by 23 judges because the death penalty is possible. According to Rabbi Yosei, the case may be tried by 3 judges because with regard to capital law, the two brothers invalidate the testimony merely by seeing the event together. And if you wish, say instead, the Mishnah discusses a case where others warned her and the witnesses themselves did not warn her. So the warning was given by somebody who was there. The witnesses were not the people who gave her the warning. And Rabbi Meir and the rabbis disagree with regard to the issue that is the subject of the dispute between Rabbi Yosei and the rabbis. As we learned in a Mishna in Tractate Makos, page 6b, Rabbi Yosei says, a defendant is never executed unless the mouths of his two witnesses are those who warn him. That the witnesses who are going to testify in court that they saw him do something have to be the same people who warned him at the time of the event. If you do this, you'll be liable to the death penalty, and he did it anyway. The witnesses have to be the ones who give the warning, according to the minority view of Rabbi Yosei. How does he derive that? As it is stated, Deuteronomy 17:6, at the mouth of 2 witnesses or at the mouth of 3 witnesses shall he that is to die be put to death. So the verse's emphasis on the phrase at the mouth of teaches that the witnesses must issue the warning themselves. Rabbi Meir may agree with Rabbi Yosei that the woman cannot be executed if others give the warning. Therefore, the trial of the defamer needs only 3 judges, whereas the rabbis in the Mishnah agree with the rabbis in Tractate Makos who disagree with Rabbi Yosei. Since she may be tried for adultery, in this case where somebody gives the warning and other witnesses see her do it, she may be tried for adultery, therefore the death penalty is possible, and therefore she can only be tried by 23 judges. And if you wish, say instead a different explanation, The Mishnah discusses a case where the testimony about the adultery was found to be contradictory with regard to the examinations concerning the minor details of the incident, but the testimony was not found to be contradictory with regard to the interrogations concerning the time and place of the incident, which is the primary substance of the testimony. So just a little bit of background here. There are two kinds of questioning that a judge will do in a case, especially in a capital case, and this is called bedikos vehakiros. Right? So the bedikos is the details. That's what we refer to by examination. And the interrogation is the major details, the date and time that something took place. Right? So you see this all the time in legal dramas, in movies and television, right? That the lawyers are trying to get the witnesses tripped up on the details. The witness is like, yeah, I was there on March 13th at 9 o'clock in the morning, and I saw this guy punch that guy in the face, right? That's the major details. And then the lawyer comes in and says, well, what color jacket was he wearing? Well, he was wearing a blue jacket. And then it turns out that the guy was wearing a green jacket. And the lawyer says, are you going to believe him with the major details? I mean, he got the small details, very important. He doesn't even know who he was looking at. Blue jacket, green jacket. It's totally different testimony. Whereas somebody else might say, well, blue and green are not that far apart, especially if it's like aquamarine or something like that. But the main details are correct. So the minority view is that, you know, if the examination, the bedikos, of the fine details produces some kind of contradiction among the witnesses, then we would disqualify their testimony. But the majority view of the rabbis is, yeah, no, we're not going to throw out testimony because a few little details contradict each other, as long as the major details, the subject of the interrogation, the hakiros, if that is correct, then we hakiros. Then we can, you know, keep that testimony intact. And so what's going on? And so Rabbi Meir and the rabbis disagree with regard to the issue that is the subject of the dispute between Rabban Yochanan ben Zakkai and the rabbis. As we learned in a Mishna on page 40a, an incident occurred and Rabban Yochanan ben Zakkai examined the witnesses with regard to the stems of figs as to their color and shape in order to expose a contradiction between the witnesses. And when he found the discrepancy in their reports about the figs, he dismissed the testimony. So Rabbi Meir adopts the opinion, and therefore a woman cannot be tried for adultery if the witnesses disagree about details like these. But the majority opinion is that from the rabbis, they accept such testimony and consequently require a court of 23 in case she is convicted of a death penalty offense. Now, the Gemara discusses scenarios concerning the testimony about a woman's committing adultery and allegations that the husband is guilty of defamation, meaning he's bringing false witnesses to lie that she committed adultery in order to reduce the amount he owes in the marriage contract or to get out of this marriage. So he's brought witnesses who turn out to be conspiring witnesses. Rav Yosef says, if the husband brought witnesses who testified that his wife committed adultery, and then the woman's father brought witnesses, and they testified that the husband's witnesses were conspiring witnesses, false witnesses, then the husband's witnesses are executed. But they or their estates do not pay money. Although their testimony, if accepted, would have also lowered the value of her marriage contract, they do not incur liability based on the principle that if someone commits a transgression that renders him liable to receive more than one punishment, he receives the greater punishment. So in other words, if you're liable to the death penalty and to make restitution for something that, you know, would have cost money to someone else, well, you only suffer the death penalty or the lashes, but you wouldn't also have the financial obligation. That's if the crime was against the same person that you would have borne a financial responsibility to her. As opposed to the following. If the husband came back before his witnesses were executed and he brought new witnesses, and they testified that the father's witnesses were conspiring witnesses, then the father's witnesses are executed, and they must also pay money to the husband, as they attempted to make him liable to pay the fine for defamation. They are not exempt from the payment because the money is for his victim, i.e. the husband, and their lives are for that set of witnesses who would have been killed if their testimony had been upheld when they tried to make those people conspiring witnesses. Right? In other words, they're going to forfeit their lives because they tried to put other witnesses in a death penalty situation, but they're also going to be liable to money because the money is owed to the husband who, if the testimony had been upheld by their false testimony had been upheld, he would have been found to be a defamer who was defaming the reputation, of his wife and by extension her father. And Rav Yosef also says, with regard to distinguishing between the different aspects of a single testimony, if a man testifies that so-and-so sodomized him against his will, right, that this man was raped by another man, then he and another witness may combine as a valid pair of witnesses to kill the defendant, meaning to have him executed for committing this rape, and specifically for the sin of homosexual sodomy, which is prohibited in the Torah at Leviticus 18:22. But if the one who was sodomized testified that the accused sodomized him with his consent, then he is testifying that he himself is wicked, meaning that he participated in this prohibited act for having been complicit in the forbidden act. And the Torah said, do not put your hand with a wicked person to be an unrighteous witness at Exodus 23:1. Therefore, the testimony would be rejected, right? If somebody says that he participated in a prohibited act as a witness against the other person that participated in the same prohibited act, like, why would we listen to him if he's, by the same testimony, convicting himself, as it were? And Rava says, well, actually, this does work because a person is his own relative, and therefore a person may not testify against himself. Therefore, a person cannot render himself wicked by his own testimony. As a result, he is deemed credible with regard to his partner in that act, his sodomizer, but not with regard to himself, since you can't incriminate yourself because you are your own relative. So he remains a valid witness to convict the sodomizer in combination with another. And similarly, Rava says, now we're on page 10a, if someone testifies that so-and-so engaged in intercourse with my wife, he and another may combine to execute him, the accused man with his testimony, but the woman's husband is not accepted as a witness to execute her, right? In other words, if a man saw his wife commit adultery with this other man, okay, well, then the wife and her paramour are both liable to the death penalty for committing adultery. Can the husband be one of the witnesses? What they're saying is, yes, he can be one of the witnesses against his wife's lover, and then, if all the conditions are met, that man will be executed. But the husband cannot act as one of the witnesses against his own wife, even though it's the same testimony, right? She committed adultery with that man. The husband is testifying what he saw. So the husband's testimony can be used to convict the paramour, but it cannot be used to convict the wife because a husband and wife are obviously very close relatives. Now the Gemara asks, what is this last scenario about a husband who acts as a witness against his wife's lover that he committed adultery with her? What is this teaching us? Is it that we divide the statement of the witness in order to accept part of the testimony while rejecting the inadmissible part? This cannot be, as the principle in this case is identical to that case, in which the witness is not accepted to incriminate himself. So the Gemara answers, the second case is necessary. It's not the same, right? The sodomy case and the adultery case. So the second case is necessary, lest you say, with regard to his own self, since a person is his own relative, we say that we divide his testimony, right? That it doesn't incriminate him because he's his own relative, but it does incriminate the other person. But with regard to his wife, one might think that we do not say so, and the entire testimony must either be accepted or rejected. Therefore, the second case teaches us that even with regard to one's wife, the statement can be divided and used to convict her lover, but not her, meaning the testimony of the husband can be used to convict her lover, but it can't be used to convict her. So we can divide the husband's testimony in that way and not just discredit him altogether since he's related to her. And Rava also says, if witnesses testify that so-and-so engaged in intercourse with a betrothed young woman, which is prohibited specifically in Deuteronomy 22:25, without specifying which young woman which young woman was involved in this intercourse. And they were rendered, right, so witnesses come and they testify that so-and-so engaged in intercourse with a betrothed young woman, without specifying which woman. And then these witnesses were rendered conspiring witnesses, right? Other witnesses came and said, well, they couldn't have seen what they said they saw because we were with them in another city at that time. So then the conspiring witnesses are executed, and they are not liable to pay money. Since they never specified the identity of the young woman, they were never in a position to cause anyone to lose part or all of her marriage contract. But if they specified that the young woman was the daughter of so-and-so, and then they are rendered conspiring witnesses, so they are executed, and they also pay money. Since in this case, the money is for this victim, i.e. the father of the young woman who stood to lose part or all of her marriage contract, and their lives are for that victim, i.e. the man and woman accused of adultery, so they are liable to receive both punishments. Even though they testified only about one act, that they saw some man commit adultery with a betrothed young woman, there were multiple victims of their false testimony, both the man and the woman who are accused of committing adultery, and the father of the young woman, who has a financial interest in that his daughter should, get to the wedding canopy without being slandered as a non-virgin. And Rava also says, if they testify that so-and-so engaged in bestiality with an ox, which is prohibited in Leviticus 18:23. And this would theoretically result in the execution of both the person and the animal without specifying, but they testified without specifying which particular ox. And then they were rendered conspiring witnesses, so they are executed, as their testimony would have put the accused to death. But they are not liable to pay money to the owner of the ox because their testimony did not pertain to any ox in particular. But if they did specify that so-and-so engaged in bestiality with the ox that belongs to another person, and then they were rendered conspiring witnesses, so they would be executed, because if their testimony had been upheld, then the man that they were accusing of bestiality would have been liable to the death penalty. And they owe money to the owner of the ox, because if their testimony had been upheld, then that ox also would have been executed. Since the money is for this victim and their lives are for that victim, they would be subject to both punishments. Now the Gemara asks, it seems that the case of the ox exemplifies the same principle as the case of the betrothed young woman. Why do I also need this case? This is essentially identical. So the Gemara answers, no, the second case was necessary to clarify a point, because Rava raised a dilemma about it. As Rava raised a dilemma that if someone testifies that so-and-so engaged in bestiality with my ox, what is the law? Do we say a person is his own relative concerning testimony, but a person does not have the status of a relative with regard to his property, and consequently the ox would also be executed because his testimony about his own animal is admissible? Or perhaps we say a person has the status of a relative with regard to his property, and therefore his testimony about his ox is inadmissible. And the Gemara says that after he raised the dilemma, he then resolved it. A person is his own relative and cannot testify against himself. His testimony cannot be used to incriminate him. But a person does not have the status of a relative with regard to his property, and so the ox would be executed. Now, it's obviously very sad that, somebody committed bestiality with an ox. Like the ox had no will in this action. A person decided to do that. The ox didn't decide to do that. But nevertheless, the Torah is very stringent with this, that, God forbid a person has sex with an animal, that animal is liable to be executed. Now, the Mishna teaches, new subject, cases concerning one who is accused of violating a prohibition that would render him liable to receive lashes must be judged by 3 judges. So the Gemara asks, from where is this derived? And Rav Huna says, the verse states at Deuteronomy 25, verses 1 and 2, if there will be a controversy between men, and they come to judgment, and the judges judge them, and they shall justify the just, and they shall condemn the wicked, then it shall be, if the wicked man deserves to be beaten, that the judge shall cause him to lie down and be beaten before his face. Right? So this is authorizing a court to administer flogging, to administer lashes. Now, when it states, and the judges judge them, in the plural, this indicates a minimum of 2 judges. And since a court may not be composed of an even number of judges, the court adds to them 1 more, and there are a total of 3 judges here. So 3 judges can impose lashes. Now the Gemara asks, if that is so, that the plural verbs in the verse each indicate 2 judges, well then the term, and they shall justify, would indicate another 2 judges. And the term, and they shall condemn, that would indicate yet another 2 judges. So there's a total of 7 judges here. And the Gemara answers, Rav Huna requires that pair of terms in accordance with the opinion of Ula. As Ula says, from where in the Torah is there an allusion to the law of conspiring witnesses? And so from where do we see about conspiring witnesses in the Torah? And now the Gemara just interrupts the question and says, what do you mean, an allusion to the law of conspiring witnesses? But it is written explicitly at Deuteronomy 19:19. Then you shall do to him as he planned to do to his brother. That's the law of conspiring witnesses, that if they testify against somebody and they're liars, then whatever punishment the defendant would have received, if the matter was established by this testimony, the conspiring witnesses receive. It's explicit. What are you talking about, Ula, that there's an allusion to the law of conspiring witnesses? Why would there be a need for an allusion? So the Gemara answers, no. Rather, what Ula meant was, from where in the Torah is there an allusion to the law that conspiring witnesses are flogged, specifically? So Ula answers, as it is written, and they shall justify the just and they shall condemn the wicked, then it shall be, if the wicked man deserves to be beaten, that the judge shall cause him to lie down and to be beaten before his face. And so now the Gemara explains the derivation. Due to the fact that the terms in the verse, they shall justify the just and they shall condemn the wicked, indicate a financial dispute in which one party is vindicated and the other party is required to pay, does it follow that, in other words, that there's 2 sides, right? A plaintiff and a defendant. That's a civil case, right? As opposed to the state versus so-and-so in a criminal matter. So since it's a civil matter, that there's 2 sides to the story, it must be a monetary case. And in monetary cases, there's no flogging. So what are you talking about that there's a beating? What's going on? So then does it follow that the verse continues, then it shall be if the wicked man deserves to be beaten? Why would the verdicts being rendered in the other party's favor mean that the losing party is flogged, right? In a civil case where there's damages, where there's money being argued over, flogging is not part of it. So rather, the verse must be discussing the witnesses and not the litigants. So if conspiring witnesses condemned the just one, and the other witnesses came and justified the one who was really the just one from the beginning, and rendered these conspiring witnesses as wicked, then, as the verse continues, then it shall be, if the wicked man deserves to be beaten, that the judge shall cause him to lie down and to be beaten before his face. So this indicates that the witnesses are subject to lashes. Right? So you might have thought that conspiring witnesses in a monetary case just have to pay whatever the defendant would have had to pay if he was found liable by virtue of this testimony. According to this view, maybe they have to pay also, but they're also subject to lashes. Then you can ask, well, wait a minute, we said if there's one or the other. Are they subject to lashes or are they subject to having to pay the money? Sounds like it's not going to, one view is it wouldn't be both. Let's keep going. So the Gemara asks, why does this law require a specific derivation? But since there is a principle that the one is subject to lashes for violating any prohibition, any negative commandment, why not derive the punishment from the prohibition, you shall not testify as a false witness against your neighbor? Meaning, once you've testified falsely in court, you have violated a negative prohibition. All negative prohibition violators are subject to lashes. It's an option that the court has. So why don't we just say, and somebody who testifies falsely also is subject to lashes? Why do you need this other derivation? And the Gemara answers, that verse is insufficient because it is a prohibition that does not involve an action, but only speech. And with regard to any prohibition that does not involve an action, one is not flogged for it, but being a conspiring witness in a monetary case sounds like you can be flogged for it because of this other derivation. I'm almost done. Questions or comments, please get them in now. The Mishnah teaches, it was stated in the name of Rabbi Yishmael, cases concerning lashes must be adjudicated by 23 judges, not 3. So the Gemara asks, what is the reasoning of Rabbi Yishmael? And Abaye said, this is derived by means of a verbal analogy between one instance of the term wicked and another instance of the term wicked from the law of those liable to receive death penalties. So it is written here with regard to lashes, then it shall be if the wicked man deserves to be beaten. And it is written there with regard to a murderer, that is a wicked man guilty of death. Just as there with regard to the trial of the murderer, the case is tried by 23 judges, so too here the case of lashes must be tried by 23 judges. Rava says a verbal analogy is unnecessary. Conceptually, lashes stand in place of execution. As corporal punishment is a kind of replacement for capital punishment, it must be judged in the manner of capital punishments, i.e. by a court of 23. Rav Acha, the son of Rava, said to Rav Ashi, if so, that lashes stand in place of execution, why do I need an assessment? Before administering lashes, the court consults with a doctor to assess how many lashes the transgressor can withstand and adjust the number of lashes so that the transgressor's life will not be threatened. But if Rava is correct, why is this necessary? Let the court strike him, and if the transgressor dies, let him die. Rav Ashi said to Rav Acha, the son of Rava, the verse states, then your brother will be dishonored before your eyes, Deuteronomy 25:3. And this teaches that when you strike upon the back of a live person. After he is dead, he is not called your brother. Rav Acha, the son of Rava, continued to ask Rav Ashi, but with regard to that which is taught in a Baraisa, Tractate Makos, if they assessed him to be strong enough to absorb 20 lashes, they flog him only with a number of lashes that can be divided into 3s, as lashes are administered in sets of 3, 2 behind and 1 in front. And how many are they? 18, right? Divisible by 3 and less than 20. And finally, at the top of page 10b, so let the court strike him with 21 lashes, and if he dies with the last one, let him die. According to the medical evaluation, he will still be alive after the 20th lash. There would be no concern of flogging a dead man, as when the court strikes him with the 21st lash, it is upon the back of a living man that the court is striking. If so, why should he not receive the last blow? And Rav Ashi said to him, the verse states, then your brother will be dishonored before your eyes. And the verse means, even after he is hit, I need him to remain your brother, and if he dies, he is no longer your brother. And that's where we will knock off. And Nina's just passing me one question from Sharon. If the non-disqualified witnesses witnessed the disqualified witnesses warning the accused, does that count as a legitimate cause or a legitimate example of him being warned? So it sounds like, according to one view, yes, right? Yes, because he was warned. We have testimony of that. And then we have valid witness testimony. But the other view is, unless it's the same witnesses who are qualified to be witnesses issue the warning themselves, if the warning was from someone else, then the whole death penalty is off the table. So according to that view, it would not work. That's what I've got for us today, and with God's help, we'll be together again tomorrow night, Motzi Shabbos. I've been getting on, here in the midst of winter, even before 7 o'clock, so why don't we say that's probably going to be 6:45 p.m. Pacific, but basically between 6:45 and 7 p.m. Pacific, I should be on the air tomorrow night. Have a great Shabbos, Freilich and Hanukkah, and may we only see light and hear good news. All the best.